and welcome to the next edition of At the Crossroads, CFTC and DOJ Enforcement. I'm Matt Kluchenek, a partner of Mayor Brown, a member of Mayor Brown's litigation and dispute resolution group, and I'm joined today again by my colleague, partner Glen Kopp, member of the New York office of Mayor Brown, part of Mayor Brown's white-collar defense team. And as you may know, each week our goal here is to bring to you an interesting and timely topic regarding CFTC and DOJ enforcement. So today we're going to focus on a topic that has been in the news lately, thanks to a number of spoofing cases, and that regards sentencing. And so this is a situation here, Glenn, where you've either got a traitor, for example, who has been convicted of a crime, and there's a sentencing, or you have a situation where you might have a guilty plea, a cooperator, and then there is a sentencing that follows. So let's dive into this a little bit. So give us a bit of a framework, Glenn, in terms of, those two scenarios.
Sure, absolutely, Matt. And so in the first scenario where you have a cooperator who has pled guilty and gets sentenced, cooperators will get oftentimes significant credit from the judge at sentencing. And that will be in connection with the government submitting a 5K1 letter, which is a letter that establishes or clarifies for the court, describes for the court, better said, what cooperation the defendant has provided to the government in investigations, has the cooperation led to convictions, but also lays out exactly what this individual has done, meaning what their misconduct is. So the judge can sort of weigh those things and provide sufficient sort of discount for the cooperation. And we've seen recently, and you mentioned the spoofing cases, Matt. In those spoofing cases, what you've seen is cooperators have typically gotten either no jail time, or really what they've gotten as they've been sentenced to time served. And for a number of these folks, we've talked about extradition, we've talked about how they qualify for cooperation. The time served sentence really calculates and considers the fact that those individuals spent a decent amount of time in jail awaiting extradition, or following extradition, they may have spent some time in jail before being released in the United States. For example, you have defendants who spent time in Australia, right, or in the UK, right? You could spend up to a year fighting an extradition. And so that will be considered by the court in making its final determination as to what the right sentencing is. But in those instances, it's fair to say that the cooperation is the key to getting a very low sentence.
So what about a situation where you don't have time served? You have a cooperator, guilty plea, provides meaningful evidence to the government, testifies on behalf of the government, so on and so forth. But again, no time served. So what's that scenario usually or typically entail?
Well, in that context, Matt, you're also, as a defense attorney, you're going to argue very strongly depending on the nature of the misconduct. And here we're talking about financial crimes, we're talking about spoofing. You're really going to be arguing very strongly for a non-jail, non-incarcerative sentence. Really, you're hoping for essentially nothing, and maybe supervised release, at most maybe probation. But that's where you're going to be under the circumstances in which there is, you qualify for cooperation, get a 5K1 letter from the government.
So clearly defense will argue for that and contend for that, but talk a little bit about the government's perspective. So they've got a situation here now, right, where they have a cooperator, meaningful evidence, maybe it results in a conviction of somebody else. What's DOJ's perspective likely to be in terms of responding to, defense counsel's proposal that there shouldn't be any jail time?
DOJ will typically sort of get out of the way on that, Matt. And so DOJ's obligation under a cooperation agreement will be if you meet all the terms of the agreement, meaning you fully cooperate, you don't go out and commit other crimes, you make yourself available, all those things, that they will provide this 5K letter to the judge. At sentencing, they may be asked about the nature of the cooperation, the nature of the underlying conduct that the individual pled guilty to. But in terms of asking or recommending a sentence, typically DOJ will stay out of that, and they will allow defense to make their arguments and engage with the court and not make any requests or recommendations in terms of the actual sentence that the cooperator will get.
Helpful. And now you say typically. Are there situations or recent or otherwise where that hasn't been the case?
You know, Matt, I can't say that I have seen a situation where DOJ has advocated for a particular sentence for a cooperator. My practice and the practice of the Southern District when I was there was that the cooperator's ultimate decision was the judge, and we stayed out of making any requests. There may be certain districts that have other practices that have sort of locked in, if you cooperate, this is sort of what the request will be for sentencing. And that may put DOJ in a spot where they might have to make a representation as to what is the best sentence. But my understanding, and I think the best practice for DOJ is to stay out of that.
Yeah.
You know, let defense counsel carry the water on the cooperator
DOJ
sentence.
got what it wants, right?
They've got their cooperation. That's right.
Happy. So let's shift a little bit to individual who's been convicted. Okay. So now you're going to have a sentencing hearing. Arguments are going to be made by DOJ, by defense counsel. Walk us through some of the arguments each party is likely to make in respect of the proposed sanction they want. Sentencing.
Sure. I mean, the way that the sentencing works here is that you've got a guidelines range, which is sort of the guidelines work such that it aids the judge, right? And sort of in understanding what are the sort of relevant or possible sentences that have been boundaries, prior history, the nature of the offense, all these things get calculated in, and that is strictly a guideline. It helps guide the judge's thinking. Then the parties will make arguments under the 3553A factors as to what is the right sentence, taking into account the guidelines, but also taking account the nature and circumstances of the offense, the individual's personal history, the need to avoid unwarranted sentencing disparities for position defendants, and then a number of other factors that the statute sets out for consideration, right? Essentially, what's a just sentence for this individual in these circumstances? And the parties will argue, sort of take each piece of that and argue over each piece. General deterrence, specific deterrence for this individual. Are they a recidivist, right? So you're thinking about what else have they done in the past? And so these are all the factors that get argued at sentencing.
So what about financial harm, right? So you take a Ponzi schemer and you can trace, losses, misappropriation, whatever the case is, to particular victims and come up with a number. But with all of these spoofing related sentencing hearings, losses are a little bit more amorphous, right? Because you were kind of looking at losses to the market as opposed to necessarily discrete victims. So what's involved with that process and what's the impact?
Sure, Matt. And so different ways that DOJ sometimes goes about approaching that. And you've seen, I think, two different ways over the course of the spoofing history. And some of that is DOJ getting better at these cases, better understanding of the conduct, talking to different experts, learning about it. And so early on, I think in the first spoofing prosecution that went to trial in the Koskia case, basically DOJ said, we can't reasonably calculate the loss. So there are alternative ways to think about the sort of the relevant numbers here. And sometimes that may be the gain that the individual had by their criminal conduct. And so Koskia, DOJ says we can't reasonably calculate loss, so let's look at something else for a figure, a number to consider in terms of making a determination as to the proper guidelines as well as the proper sentence, because the number, meaning loss, like in fraud cases, the loss to victims is a big driver, right? What you've got recently in the Chanu and Vorley cases, right? DOJ said, actually, we're going to come up with a different approach to try to actually calculate loss, bring in an expert, have the expert—
Loss to the market, right?
Loss to the market, have an expert do an analysis, and present that as our argument for the loss amount for this particular defendant's conduct. And the defense counsel will say, we don't think that's reasonable. We don't think it's possible to calculate loss. In fact, arguably, there really is no loss to the market. So the number should be 0, and that will drive the guidelines calculation. And that also underpins the nature of the offense. How bad could this really be if you can't show any individual victim who lost money?
Right. Okay. Thanks, Glenn, and thanks to everyone for watching this episode of At the Crossroads CFTC and DOJ Enforcement. See you next week.